This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast and beyond. It's Friday. It's another time for Ask a Lawyer. This is actually the first show of our second year. So we've managed to survive. Even though sometimes I have a producer here who's a little adversarial.
Oh, stop.
That's right. I got to bust your chops. And I hope you've all had a nice week and are looking forward to a nice weekend. I think it's still supposed to be a little bit cool. So I guess no swimming.
No. Unless you have a heater, right?
Well, only if I put it on a couple days ahead of time.
You have to plan
so I don't
ahead.
have to spend $600 a month in electrical bills.
You have to plan ahead if you'd like to swim, right?
Exactly.
Okay.
Got to make plans ahead. Got to put it in the book and, sign in.
Yeah.
All right. Well, so today we're going to do a little something new.
Mm-hmm.
We're going to try to do this once a month. We have a guest with us in the studio. It's a colleague of mine. It's Andrew Wright. He's an attorney with Wright and Mancini in Port St. Lucie and in Palm City. And we're going to be discussing today workers' compensation law under the Florida statute and how to best protect yourself in the event you have the unfortunate occasion to have an injury on the job. Before we sort of get to that, I'd like to inundate Cheryl with some phone calls. Folks, it is Cheryl's birthday today, so just harass her, please. Call 772-781-8003 and say happy birthday to Cheryl. I'm sure she has nothing else to do, and she will appreciate it.
You think she's listening?
She is always listening
Okay.
in case I give her instructions.
Well, happy birthday, Cheryl.
See, Cheryl, I didn't forget you. You might have thought so because I'm not in the office, but I didn't forget. I don't know if there will be anything delivered today. No, there won't. We'll deal with it on Monday. The other thing I sort of want to mention is tomorrow we have another speech tournament for Lincoln Park Academy. And this is the qualifying tournament for the Florida Forensic League State Championships in April. So we are a little bit more than halfway through our first year at Lincoln Park Academy with the speech and debate team. As we mentioned last week, a couple weeks ago, we finally won our first awards, which is pretty good for a novice team that was competing in a varsity tournament. And excited, looking forward to seeing what will happen tomorrow. And we have some really, really good quality young men and women who came in with absolutely zero experience. And the magnitude by which I've watched their improvement is just extraordinary. It's exciting. It's fun.
Well, teenagers have a natural ability to debate anyway, don't they? You're just giving them guidance on how to do it.
Trying to tell them how to do it
right.
Yeah, and the first lesson we give them is don't watch Congress.
Yeah.
Don't do it that way. There's a better way to do it, more logical, more organized, more rational, more reasoned, more likely to be persuasive if you're not trying to out-yell your opponent. Sometimes we do that in a courtroom, too.
Yeah.
And then the judge has to step in. Once, I think the worst admonishment I ever got was, Mr. Address, please conduct yourself as a gentleman attorney. That was a very harsh admonishment. But I got the message. All right. So, Andy started out, I guess, in the public defender's office, didn't you?
Yes, in Okeechobee County back in 1991. Believe it or not, it was still an open-air courtroom back then, out of the Clarence Darrow movies.
That's basically right. Now there's some breezeways and a little bit of interior.
Yes.
They finished building the set.
Yeah.
Yeah, I remember when I used to go to Okeechobee too. It was a very interesting courtroom. And then I guess at some point you transitioned into private practice, and we're representing the evil side, the insurance companies.
The evil insurance empire, as I call it, but did that for about 2.5 years in West Palm Beach. And I think the fact that I'm a plumber's son and my mother was a church secretary, I realized very shortly that I was on the wrong side of the table. So I started in 1994 representing injured workers and had moved up to Stuart and in Palm City, and been doing that ever since 1994.
And I do remember, because that's when 1996 is when I came to Stuart from Daytona. And in 1996, I was able to get from my then home in Port St. Lucie, to my office in Stuart in 18 minutes.
Yeah, not probably twice as long, if not
twice
more.
as long.
Yes.
Twice as long. Yes, absolutely. Yeah. On the best of days. But yeah, I also, when I first moved to Florida from New Jersey, and that's where you're from, right?
I am from New Jersey.
You're
yes.
actually you're from the town which boasts Little League World Champions, don't they?
Toms River, New Jersey. That's right.
Not very far from where I grew up in Marlboro.
Yeah.
So we have that in common. And when I first moved down here from New Jersey, the first real job I got, other than a part-time job, was in Daytona Beach. And I found myself representing, doing insurance defense work, too, for civil litigation. And it was not exactly my cup of tea. I found myself often wishing I was representing the other side. And so then I moved down here to Stuart and have been ever since. The right people, the underdogs.
Hey, the town's named after you, right?
Well, you know something. You know how they do when they're trying to recruit big-time football players, and they get you into their wonderful stadiums. And they have the lovely stuff on the jumbotron, and it's just wonderful. When I first came down to Stuart to answer a blind Florida Bar Journal ad, I saw this lovely water tower that said Stuart. And I was wondering, were they recruiting me?
Yeah.
But it turned out this place was here long before I got here.
It's just coincidence, right?
Yeah. So I don't own the town, and I don't have any relatives that own the town. And
But you said this town, it's got my name on it.
It's got my name
I
on
must
it.
belong here. It's got my name on it.
And with a name like with the last name like Address, so you say Stuart Address, and inevitably, I've heard it all my life, but inevitably in Stuart, you hear no, your name.
Yeah.
I said, well, that is my name. Well, that's your name? I'll tell one very quick story before we get to Andy. When Martin Memorial, now Martin Health Systems, now I think Martin Health Systems Cleveland Clinic, when they first went to a newer computer system, probably about 10 years ago, I went in for a minor procedure in one of their outpatient facilities, and it was turned out to be the first day that the new system was active. They had been prepping it all weekend and doing dry runs. And I come in, and they can't find me anywhere. And I have the paperwork. I'm scheduled first thing in the morning. And finally somebody looks up and says, oh, here you are. We don't have an anesthesiologist on call. Why not? Well, because we saw your name, and we thought this was just a dummy entry for us to test all weekend.
Oh, no.
But I tell you. They immediately called an anesthesiologist. I didn't want to undergo the procedure without anesthesia.
Yeah, no.
That's the way it works. So anyway, over the course of a year, we have talked about a lot of substantive topics. And folks, just like we always say, we're sort of going to focus today on workers' comp, but if you have any questions at all about anything, feel free to call. It's 340-1590. If I can answer, I will. If Andy can answer, he will. And if the two heads can't figure out anything, well, we'll tell you you're out of luck. No, well, we'll try to help you and figure out where to send you, politely. So give us a call with any questions you might have, and we'll try to do our best. That's what we're here for. But in talking about workers' comp, I guess the first place to start logically would be, who's covered under workers' comp law in Florida?
Well, essentially, Stuart, it's all state and private employment, with rare exceptions. It's generally, if you're in the construction business, it's one or more employees. If it's private or state employment, it's 4 or more employees, and you're covered by the Florida workers' compensation law. Now, there are some exceptions. Federal employees, such as postal workers, are covered by a separate federal workers' compensation law. But the Chapter 440, which covers workers' compensation, basically covers all state and private employment, with some rare exceptions.
All right, and so the numbers are different. If it's a state employment, I think you said you have to have at least one employee.
Well, state or private employment.
Okay.
If you're in the construction business.
Oh, construction. Okay.
Construction is 1 or more employees. Private, other employment, whether it's a restaurant, a body shop, whatnot, that's 4 or more employees. Okay. There are some places where there are exceptions where corporate officers can exempt themselves as an employee. So, somebody may think, well, we have 4 employees, so my employer should have workers' compensation, but they don't because there's the corporate officers exempt.
All right, so I know in my areas of law there are all sorts of different statutory prerequisites in terms of numbers of employees. It's 15 in Title VII for discrimination. It's 50 under the Family Medical Leave Act. What happens in a situation where, let's say, it's a private employer, non-construction industry, and they only have 2 employees? Is there no coverage at all?
There essentially is no. You're not covered by the workers' compensation law at that point. Now, that doesn't mean necessarily that you don't have a cause of action against that employer, but it's just the Workers' Compensation Act doesn't apply.
So the cause of action you might have would be if the employer was negligent, perhaps a negligence cause of action.
Yes.
If the employer, did something really stupid and borders on willful, you may have a slightly different cause of action.
Yes.
Could there ever be a cause of action in a breach of contract?
Oh, absolutely. Even if they're covered by workers' compensation, there could be a breach of contract situation, depending on the circumstance. Yes.
Okay. Now, how are you, if you're an employee, going to know, for example, well, we have 4 employees, but because one of the officers has exempted him or herself, there's really no coverage?
Well, look, it's one of these situations where if you get injured on the job in any way, shape, or form, you've got to at least look into your rights. Now, technically, an employer is supposed to tell the employee by way of posting somewhere that's obvious at the place of employment that they have workers' compensation coverage.
Sort of like in the break room.
Yes. And who the insurance company is, so that you know who to contact in the event that you have an injury on the job. But that doesn't always happen. So the best thing to do is consult with an attorney, pursue your rights, call the state of Florida. There is a division of workers' compensation that actually is helpful. I don't have the 800 number offhand, but I'm sure I could get that and provide that to anybody that's
probably very easy to Google.
It would be very easy. So the Division of Workers' Compensation up in Tallahassee would be able to also probably provide some guidance as well.
All right, and let's circle around to what you should do, if you have an incident on the job. But before we get there, are there other exceptions, such as casual employment, independent contractors, things of that like?
Yes, there are. There are independent contractor provisions, although in the workers' comp law, Chapter 440, it gets very technical. What some employers call independent contractors are really employees. So even if the employer gives you a 1099 and calls you an independent contractor, you may in fact be an employee.
Right. Now, we run into that all the time when it comes to Title VII or what have you, and whether or not the minimum number has been met. And what we often find is that employers like to characterize an employee as an independent contractor. First of all, it allows them to escape the employer share of Social Security and Medicare taxes.
Of course.
Okay, and there are a number of tests to determine whether somebody is an independent contractor or an employee. They're relatively similar, but the IRS has their own test.
Yes.
And in the 11th Circuit, in our Federal Court of Appeals, the 11th Circuit has come out with a test of factors that is similar to the IRS, but not exactly the same. And then the Department of Labor has a test on the distinction between independent contractors and employees.
And there's similar provisions. I would imagine if we compared those provisions to the provisions in the workers' compensation law in Chapter 440, you would find that they're somewhat similar, if not identical. Things like, I'm sure, direction and control. Do you have set hours? Does the employer provide you the means of doing your job by way of tools, supplies,
right,
whatnot?
So if you believe you're an independent contractor, you've been told you're an independent contractor, you're being paid as if you're an independent contractor, and you have an injury, I guess the best advice would be the same advice we would give anybody, which is call a lawyer.
Yes. Call a lawyer and know your rights. It's free of charge. There's no charge for consultation. My firm, there's other law firms out there, I'm sure. The phone call is free, and then you go in that direction. And if an attorney such as myself can help you, believe me, they will gladly open their door and welcome you in.
Right, and it's frankly, it's in your best interest or any other workers' comp attorney's best interest, because if I understand correctly, any attorney's fees that are recovered are set and approved by statute.
Yes, they are. Yeah.
So it's not like in my area of the world. Let's assume there's no statutory attorney's fees provision. I'm going to get a percentage of whatever the client recovers. It doesn't exactly work that way for you, does it?
No, from a standpoint of the fees, it is a contingency fee arrangement. So if I do not get benefits for my clients, I do not get paid. There are settlements. There are percentages of the settlement, just like an auto accident or a slip and fall. The percentages are somewhat lower than the standard, auto accident
right,
contingency fee. There are also provisions in the workers' compensation law that provide for the insurance company to pay essentially bad faith attorney's fees if an employer or their workers' compensation carrier deny the claim and you have to engage an attorney. Bottom line is, you do not, as an injured worker, walk into an office and pay money up front. It is no charge to retain an attorney.
And now we might sort of be jumping the gun a little bit ahead, perhaps, but if I'm an employee and I get hurt on the job, and I know that you're going to take a percentage of my recovery, why shouldn't I just handle it on my own?
Because the insurance company is not going to tell you what your case is worth. The insurance company is not going to tell you what you are entitled to. We have a lot of situations. As a matter of fact, if a injured worker settles his case without an attorney, the workers' compensation judge is actually required to have a hearing to approve the settlement. And we see a lot of situations where the judges do not approve those because the insurance company is never going to pay you individually without an attorney what your case is actually worth.
So is the judge then interjecting him or herself into the reasonableness of the settlement?
Yes, in some situations, yes.
Okay, that's interesting.
Now, I knew someone who was the employer directly put them on workers' comp while they were hurt, right off the bat, and the workers' compensation insurance company just stopped paying. The employer fired that person.
That's when Andy calls me.
And
Yes.
and they, of course, then you're pushed into either finding, getting better very quickly to get another job, or getting a lawyer.
Yes, to get those benefits reinstated. And as Stuart said, also then that person comes to me and I get Stuart involved because they now have a retaliatory discharge action. Now, there may be employment issues that Stuart will deal with beyond this, but an injured worker needs to know that there are provisions, and a lot of the provisions in the workers' compensation law are in favor of the insurance company because the law is essentially written by the insurance lobby up in Tallahassee, who controls Tallahassee politics up there. So, but there is a provision 440.205 that says an employer shall not discharge, harass, threaten to discharge an employee by virtue of pursuing workers' compensation benefits. So that person comes to me and says, I got fired because I was asking them to give me a doctor or provide me lost wage because I've been out of work for a month. And the employer fires them by virtue of pursuing those benefits that they have a right to under the law. Then Stuart has a separate cause of action in circuit court for that retaliatory discharge as under the provision of the Workers' Compensation Act.
And that's where, whether it's Andy and I or whomever, attorneys tend to work in tandem because we've gotten plenty of calls in our office where, somebody says, well, why should I pursue this? It's not that big, and what if they fire me? And, the advice we always give is you don't exactly know what your rights are. You don't know what's going to happen with the injury 2-3 months from now. You don't know where things may go south. It's in your best interest to at least consult with a workers' compensation injury attorney. And there is protection against retaliation under the statute. And if the employer is foolish enough to take what's called adverse action against you, well, then somebody like me can step in separate and apart from the workers' compensation claim and deal retaliation under the workers' compensation statute, which is more of a civil claim that's pursued in circuit court as opposed to in the workers' compensation courts.
Yes. And there's other things that they may deny the employee that may give rise to an action on your part, such as denying them COBRA if they had health insurance and the employer refuses to provide that. Or there were vacation pay that was accrued and vested that they're refusing to pay, or they withhold the last paycheck, or I find out in talking to the person about their workers' compensation claim that they were actually working 45 hours a week and were entitled to overtime, and they didn't get paid time and a half for their overtime. So then Stuart would step in on a separate cause of action.
And that's really a good illustration, not just in the interplay between workers' compensation and a general civil litigation attorney like myself, but it's a good illustration of how a lot of areas of law interplay with different types of attorneys. You can be consulting with one type of an attorney and that attorney discovers that you have potential claims in another area of the law and refers you to an attorney that handles those types of matters. Doesn't mean you're leaving the attorney, it doesn't mean you're leaving me necessarily, but it may mean that you have two different attorneys working together in two different areas where they each know the law to try to provide you with the best umbrella of protection so that you have a reasonable opportunity to do battle against those who usually have superior resources. And this is where we come in.
And ultimately that the injured party needs to make sure that their rights are protected all the way around. And let's not kid ourselves. Employers have attorneys, insurance companies have teams of attorneys. They are getting, once a person is injured on the job, the employer and the insurance company is engaging legal counsel immediately, which is why I always suggest to someone, what do you do when you get injured on the job? Either first go to an attorney or first go to the emergency room and then go to an attorney.
Right. I wouldn't say don't call the 800 number that's listed on the little thing in the break room, and file your claim. Find out what's going on first. The attorney can always file the claim for you.
Yes.
And usually the way they file it, the way it's going to be phrased, to make sure that this, that, or the other thing is protected, it's covered, it's mentioned, maybe better than the way you're going to initially file it. And obviously there are some opportunities to amend, but are there things that can be lost if they're not mentioned in the initial claim?
Yes, as a matter of fact, there are reporting requirements. As a general rule, you have to report your injury to your employer within 30 days. Now, I wouldn't suggest to anyone that they wait 2 weeks or 3 weeks. Don't wait till the 29th day to report that accident. But you do have 30 days to report it. And you need to report it to somebody in a supervisory capacity. Make sure that what we call a notice of injury is filled out. That's what the employer is required to do. Fill out a notice of injury, which is then sent to the insurance company.
So don't just tell your boss, I got hurt.
No. Make sure that that notice of injury is filled out. And then if you feel like if you know for sure that they have not filled out the notice of injury, or you suspect that they are just listening to you in one ear and out the other ear and nothing's being done, then document it by way of going to an attorney who can file a claim for you immediately within that 30-day period. Go to a doctor, whether it's an emergency room, a walk-in clinic, get a paper trail. Make sure that that emergency room or that clinic documents specifically the history. I was reaching down in the cooler to pick up a case of soda and my back popped, and then I fell over and I hurt my shoulder. So I hit my head. Document not only the mechanism of injury, the way it occurred, but also all the body parts that are affected, whether they're severe or not. A lot of times I have clients that come to me 6 months after the accident occurred. The walk-in clinic or the insurance company is focused on the fact that they have had a low back injury, but the person says, I also hit my head and now I'm having these severe headaches. If they're not documented, it's very difficult to reinvent that wheel. Not impossible, but it makes my job as an attorney and advocate much more difficult for that worker.
I've noticed recently, if you go into like the emergency room, they're asking you, is this an injury? Did you fall? Were you hurt at work?
They're doing that for a different reason, though. They're doing that because, as opposed to billing your private insurance company, it's going to be processed in a different way.
Okay.
Yeah.
That's all they care about.
Okay.
Yeah. Well, we're obviously going to continue with Andy, but folks, it's 340-1590. Call us with any calls about workers' compensation or any other issues that you may come up with. When you are documenting your injury, when you go to the ER, what have you, and then all of a sudden you get a call from your employer, I want to send you to Dr. Bly. What do you do at that point?
Well, generally it should be the workers' compensation carrier, the insurance company that is sending you to that doctor. The employer sometimes will pay for treatment, but to me that would be a red flag. That means the employer is trying to deal with it on their own and avoid the insurance company, and chances are the insurance company doesn't know about that injury. Now, it's good from the standpoint that the employer is providing care and hopefully paying that bill, but as an injured worker, make sure that you know that the employer is actually paying for the doctor, because you could unwittingly get a medical bill there.
Do you have the right to choose who you want to provide care, or can the employer or the carrier say, I want you to go see this particular physician, this surgeon, what have you?
Unfortunately, under the workers' compensation law, the way the rules are set out, the insurance company, by and large, directs medical care. Now, there are some exceptions where if you ask for certain treatment and the insurance company doesn't provide it within a certain amount of time, you have the right to seek treatment on your own. Or there are what we call self-help provisions, where an employer doesn't report the accident to the insurance company. An injured worker comes to me. I get them set up with medical care because as you know, Stuart, we deal with doctors in different arenas. So I make sure that that person gets medical care. We call that self-help. Ultimately, when I get an insurance company involved, then I'll get the insurance company to provide those doctors. But by and large, unfortunately, the insurance company is going to control a lot of the medical care.
We have a call. I will see whether it's for you or for me.
Okay.
We have Barry on line 1. Hello, Barry. How can I help you?
Well, hello, sir. Yes, I hired Rocky Mancini after I was involved in a car accident and was injured. And I spent 6 years with Rocky Mancini, going to arbitrations, depositions, doctors, x-rays, MRIs. And after 6 years of living hell, I never even met Mr. Wright or Mr. Mancini. I was always sent to an individual intern or whoever. I went through like 3 different interns who eventually, I don't know where they went. I kept getting referred to someone else. After 6 years of hell, I was finally told, sorry, we need to go to court, and if you lose, you will have to declare bankruptcy. At 67 years old, it was too high of a risk. It was the worst experience of my life.
All right. Well, I thank you for your call, and I will let Andy address that because I'm sure there's we all have these situations, and what kind of a circumstance is that?
I don't know, but Barry can feel free to call me at the office at 878-9800. And our door is always open, and this just seems like an anomaly to me, and I can't address exactly what this is, but I'm more than happy to meet with Barry or whoever Barry is.
And I think we all come across this, unfortunately, when you've practiced for any period of time. The best of attorneys really do try to help, and even those can't help all the time. I have a case right now, for example, that's been in court for 8 years. Why has it been in court for 8 years? Because we have attorneys on the other side that like to pull out every nook, cranny, evidentiary rule, every obstructionist effort that they can to delay things. And sometimes there are things you can do about it. Sometimes the judge is just going to put things off. I'm obviously not in your office, so I don't know how you're set up, but I know that in our office, we start out with people contacting a paralegal. Now, my office is a one-attorney office, so they're usually dealing with me pretty soon thereafter. But, you're not able, unfortunately, to always satisfy everybody. And sometimes there are situations which are simply beyond control. And sometimes facts develop in a case which make them more complicated. It changes everything.
Yeah.
So, right, we obviously neither I nor Andy can know exactly what the situation is, but just like Andy said, when I have a client, whether they've expressed dissatisfaction either in a telephone call or an email, it's usually not a bar grievance. But the first thing any competent attorney is going to do is say, well, talk to me. Let's figure out what really happened here, and if there's anything that can be done, certainly we'll try to do it. But I guess that happens, unfortunately, and I feel bad for Barry, but obviously I don't know his circumstances.
And when you get to the point where you need a lawyer and you need to be negotiating with an insurance company and their lawyers, things are going to take time.
No question about it.
Most cases take a while.
Yes, but I can assure you, I know how our office works, and me personally in the workers' compensation arena. I have staff. I have a paralegal who's a certified paralegal. Now, despite that, I probably do at least 60 to 70% of the initial intakes myself, personally, where I'm meeting with them.
Okay.
And in those situations where my paralegal is the intake person, I'm shaking that person's hand and meeting them if I'm in the office. Now, if it happens to be where I'm on vacation or I'm in court or I'm out of the office on some other matter, I end up meeting that person. So, I can't speak to Barry's situation, but that seems that strikes me as odd. Our office meets with people. Our door is always open. We have multiple attorneys. So.
And, you know, I've talked on prior shows about, you know, some of the more common complaints that clients have about attorneys. And, you know, a number of clients who have come to me over the years wanting to switch attorneys. And one of the first things, you know, I try to go through is, well, what was the problem? If it's a problem of, well, my attorney's not communicating with me, well, you know, what have you done to try to make sure that you get the attorney's attention, assuming you're right and, you know, the attorney has maybe dropped the ball or something.
Mm-hmm.
Have you done anything? You know, if the client hasn't done anything, I said, well, before you try to hire me or somebody else, why don't you send an email, send a certified letter, send something to get the attorney's attention and see if maybe there's something that, you know, you weren't aware of, and, you know, maybe it requires an attorney-client conference in the office to try to, you know, either smooth out a misunderstanding or a miscommunication, or just a misapprehension of what the procedures are and how long it takes.
And people are different too. Some people they understand their patient. They know that these things, like I know the back and forth with an insurance company. They have so many days to respond. Days go by. Some people need to know that you're working for me. They need that connection, and some people are just, I'll wait till I hear from you. So it probably all depends on the client.
The client, case by case. Mm-hmm. And look, we live in an age now with faxes and email and cell phones, text
instant
messages,
news.
instant news.
Yeah.
But you're right. For instance, when we file what we call a petition for benefits for either a lost wage or a medical treatment for an injured worker, the insurance company has 30 days to respond.
Mm-hmm.
Now,
their response be, "Hey, we got your letter."
And
then now they have more time before they.
No, they have 30 days to either pay or deny.
Okay.
And then there's a court process that ensues. So, you know, we generally, if a client comes to me and says, the walk-in clinic referred me to an orthopedic spine specialist,
mm-hmm.
we will tell them, we can file the claim now because we have the referral on your behalf. But the insurance company has 30 days to respond. Now, that's not 30 days to provide an orthopedic spine specialist.
Mm-hmm.
It's 30 days to respond to schedule an appointment. So we generally tell our clients it's 30 days. Now, those people, some clients may be calling on a daily or weekly basis saying, where's my doctor, where's my doctor? You have to communicate. And as Stuart said, if there's a situation I know with our clients, if I'm the client, the injured worker, and I want to meet with my attorney, I'm going to call the office and say I want to have a face-to-face, or I want to have a phone conference with the attorney. And shame on me if I don't provide that person. I don't deserve to be their attorney if I don't give them the time of day,
mm-hmm.
if my door doesn't get open for them. And I can tell you personally, if one of my clients wants to meet with me face-to-face, they meet with me face-to-face.
Right.
That's a guarantee.
Mm-hmm.
I agree, and it's the way I handle it too. I mean, you know, I use my paralegal for quite a lot of things. But, you know, during the initial consultations, the clients are always told, you know, if Cheryl cannot help you, or if you feel you have a need that you need to talk to me, tell her, and you'll get in touch with me.
Mm-hmm.
Or send me an email, because chances are, if it's easy, you may get an answer in 30 seconds, or you may get an answer at 3 in the morning, but you'll get an answer.
Right,
you
right.
know?
Mm-hmm.
I think there are good and bad apples in every single field in existence. But, you know, any competent attorney, the primary currency we really have is the referrals and our reputation. It's not something that any competent attorney really wants to squander very easily.
Right.
So let me ask you this. You're injured. Obviously, there's some rights to medical treatment. There's some rights to wages. What essentially are your rights as somebody who's been injured on the job?
All right. Well, you're entitled to medical care, and you're entitled to lost wage to the extent that you're either taken out of work completely, or you're given restrictions by your doctor such that your employer does not provide you with at least 80% of your pre-injury earnings. So, component-wise, medical care. Generally, the person gets sent to an emergency room or a walk-in clinic. That's usually the first line of medical care. Then workers' compensation is set up almost like managed care, where there's a primary care doctor. More often than not, your first main authorized doctor is a walk-in clinic, urgent care type doctor. That person will do the workup, possibly send you for diagnostic studies, what they call an MRI, to see what's going on with your neck or your back or your shoulder, CAT scans, nerve studies. Once it's discovered that you have a serious injury or something that is not going to heal within a short amount of time, you may get sent for physical therapy in the interim. You may get medications. But once that walk-in clinic establishes that you need to see a specialist, they will then refer you out, an orthopedic spine doctor or a neurosurgeon or a hand specialist or a neurologist or a pain management doctor. In the interim, those doctors, whether it's the walk-in clinic or the specialist, they are going to identify what your work status is. And they should, and I encourage my clients, do not leave the doctor's office without what we call, again, getting technical here, it's called a DWC-25. It's a 2-page work status form that has all your information, has your diagnosis, has what the doctor is recommending by way of medical care, and then on page 2 has your work status addressed, whether you're completely out of work or you can work within certain limitations.
Okay.
Light duty, no lifting greater than 10 pounds, no repetitive lifting, no repetitive standing, no repetitive sitting, whatnot. If you're taken out of work completely, you are entitled to 66 2/3 or 2/3 of your pre-injury earnings, which is established by 13 weeks or 3 months prior to your industrial accident. And so you get that 2/3 tax-free, by the way. So it's probably not the full equivalent of what your take-home pay is, but it's pretty close to it.
So who's paying you? Is it the insurance company now paying you, or is it your employer paying you?
More often than not, it's the insurance company paying those checks. Now, there are certain situations, there are certain employers, some of the municipalities, some of the bigger employers pay those checks directly for a short amount of time. Some of those employers or municipalities pay full wages even. But once the insurance company gets involved, it gets into that 2/3, 66 2/3. If you are taken out of work by way of restrictions, where the employer doesn't accommodate those light duty restrictions, the insurance company is going to pay you what's called temporary partial disability. And if you're not earning anything from your employer, your wages will go down to 64%. It's a small deviation. So you're out of work 2/3. You get released to return to work with a 5-pound lifting restriction, but your employer can't accommodate that. You get 64%, and that's called temporary partial disability. There's a quirky formula in the workers' compensation law whereby if you are returned to work with your employer, but you're not making 80% of your pre-injury earnings, then the employer pays you whatever you're earning, less taxes, and then the insurance company will make up the difference. It's a convoluted formula.
Which is why you need an attorney.
Yes,
Yeah.
it is. Now, you're entitled, there's a lot of other things you're entitled to that they don't necessarily always tell you about. I have clients all the time that come to me, they're a year or they're 6 months or they're 2 years into their accident, and I say to them, do you have mileage forms? And they look at me very confused saying, what do you mean mileage forms? And I say, well, do you understand that when you go from your home to your physical therapy or your home to the hospital or your home to the doctor, you're entitled to mileage reimbursement?
Yeah, because you wouldn't ordinarily be doing that.
Yes, and your injury caused you to have to have that mileage. So you have gas and you have wear and tear on your car, and you're entitled to be reimbursed for that mileage. Good thing is, if somebody comes to me 2 years after their accident and they've never submitted mileage, we can get a payout sheet from the insurance company, show all the doctor treatment, and the person can recreate their mileage and submit it. There's no statute of limitations, if you will.
Okay.
As long as your workers' compensation claim is open, you can submit that mileage back to day one.
Now, like a client, I now have a host of questions, probably half of which I won't remember. So let's just try from the top. Obviously, you must know that there are certain doctors that insurance companies like to use. Not all of them are independent, impartial, and looking out for the employee's best interests or fully their best interests. What happens if you see that an employee has been referred to an orthopedic that you just know from experience is just, it's not who you would want your person to see? Do you have any recourse?
Unfortunately, if the insurance company has responded timely to that initial referral to a specialist, the injured worker is at least going to be obligated to go to the initial appointment with that doctor. Now, if they are dissatisfied with that doctor, they do have the right to a change of doctors. Unfortunately, the insurance company gets to pick the change in doctors. But again, getting back to technicalities, this is where it's good to have an attorney involved, because they don't necessarily always tell you this. If they don't identify that doctor within 5 days, that one-time change, then you as the injured worker have the right to pick your own doctor, which obviously would be much more beneficial. There are also situations where I have clients that live in Port St. Lucie, and the insurance company wants to send them to Boca Raton or Delray Beach, or even further south or further north, sending them to Melbourne or Orlando for a specific doctor. Well, we know why the insurance company is sending them to that specific doctor. You would not be sending somebody from Port St. Lucie, where there are doctors probably 15 or 20 within a 5-mile radius. You wouldn't be sending them 50 or 60 miles away unless you had a specific reason to do so. So those are situations where we do.
Would it be because they're making it difficult for you to keep your appointments?
Difficult to make the appointment, and the insurance company knows what they're going to get out of that doctor.
Okay.
Essentially, the insurance company has written the doctor's report for them.
Okay.
They know that's primarily. But yeah, it's also a disincentive for someone.
Yeah, I can't make it, so yeah.
Yeah, and they get fed up. They want you. They would prefer, the insurance industry, I'm sure, has a bean counter that says if we delay or deny, a certain percentage of injured workers will just get fed up.
And they'll go away.
And go away and take themselves out of the workers' compensation system. They will seek medical treatment on their own through their health insurance, which you can do as an injured worker, but the doctor is not recognized in workers' compensation. And once you take yourself out of the workers' compensation system and start getting medical treatment on your own, it's hard to get back into the system sometimes. And then it creates problems with health insurance wanting to get reimbursed sometimes after the fact, because they found out that
it was
a workers' compensation claim, as Stuart said earlier about the checking the boxes on the forms at the doctor's office. There's reasons why.
Okay.
So.
Well, now, I've heard about independent medical exams.
Yes.
Obviously, at least I assume, the employer, the insurance company, has the opportunity to send you for an independent medical exam. As the attorney for the injured worker, if you're not happy with who they're going to, do you have the opportunity to petition for an independent medical exam of a doctor of your choosing?
You do have the right to get an independent medical examination. Unfortunately, you have to pay for the doctor yourself. Now, as a practical matter, that's where getting an attorney involved helps, because there are doctors that we deal with that will do the independent medical examination and work with us on the charges. There are also ways that we can possibly, if we need money up front, I can't front
Right.
necessarily, but we can get advances through the insurance company. You are entitled under certain financial situations to get an advance of money, whereby you may be able to provide to get that independent medical examination. So there is, and most of the insurance companies have opted out of certain arrangements, but there are situations where you can get an independent medical examination paid by the insurance company, but it's a rare circumstance.
And what about letters of protection?
There are no letters of protection in
Really?
workers' compensation. They do not exist.
See, that's where attorneys that don't practice in that area of the law don't know anything.
Yes.
I wouldn't have known that.
That's a term of personal injury, and yes. So
All right, but you won't believe it, Andy. It's 10:55.
Yeah.
amazing. The
Okay.
time flew by.
So
Kind of like the month of January.
that's right. The month of January went very
gone.
quickly.
Yes.
All right. What happened? You mentioned, you get this, form with letters and numbers and, the status of returning to work, and there's a 5-pound restriction, and the employer decides he can't accommodate it. I never like that word in my business, can't. I usually hear doesn't want to. If it's certain situations in my area of practice, that could be a violation of the Americans with Disabilities Act. If they're not providing a reasonable accommodation, what happens here in the workers' comp situation? Do they have to provide that accommodation, or are they allowed to, omit it?
No, they are not required to take you back.
Okay.
I mean, there are probably some jobs that have either contracts, whether they're part of a union or a municipality. There may be FMLA situations
Right.
where the employer, but by and large, we live in a state that is an at-will employee state. An employer can, unless you're in certain protected classes, as you know
Okay.
from your expertise, you can be hired and fired at will,
Right.
because we are an at-will employee state.
And so we wind down. We do have Mike on line 1. Hello, Mike. How can we help you? Mike, you there? Mike, if we have somehow...
Let's see.
let's see.
Yeah. There's no lights on. Gone.
All right, Mike, if somehow we got dumped you or something,
He may realize that we only have 1 minute left in the show.
give us a call. All right, well, Mike, if you'd like to talk to Andy, what's your number, Andy?
878-9800, and our website is www.4injuryhelp.com.
And if it was for me, give Cheryl a call at 781-8003. Well, this has gone very fast, Andy. I don't know if it felt fast for you.
It did. We could spend probably another hour, and
probably
it would
could.
be just as much fun, and I appreciate the time today.
Well,
Stuart.
I think it's helped the people who listen to us, and I appreciate you coming in. Folks, this is Stuart Address for Ask a Lawyer. We'll see you next Friday, and have a wonderful weekend. And if it's cold, enjoy the cold. And if it's warm, get out to the beach. Take care.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.